And we're with Doug Weinstein, defense attorney for Deamonte Kendrick. That's Jeffrey Young Thug Williams' co-defendant in the YSL trial. He is on screen on YouTube. He's not on screen on TikTok, but eventually I'm going to get everything set up so we can simulcast here. But if you want to see him, head on over to YouTube. But everybody, thanks for joining me. It's a big news day. It was unexpected this morning. I was under the impression, and we'd all been told that this hearing or the meeting that they were going to have about the transcript, this is in relation to the ex-party meeting that happened back on June 10th between the judge, the prosecutors, and Kenneth Woody Copeland. They were going to have a meeting in chambers about that because it was even talked about how Brian Steele asked for Young Thug to be able to attend, and Judge Glanville wasn't going to allow that. But then this morning, the court actually sent out an email on the PIO list and said, actually, this is going to be a public hearing. Everybody is welcome. So it ended up being streamed. We still don't have the details of this transcript public, but Judge Glanville had some surprises up his sleeve and actually took the recusal motions against him that he's already rejected and says, I'm going to send those to another judge. And he said, and until those are decided, the proceedings are on hold. So the prosecutor, Simone Hilton, even said, is there a way to streamline this? We're a little concerned about just holding the jury indefinitely. And the judge just said he couldn't do anything about that. So, Doug, thank you so much for joining us. Did I summarize things accurately? If you were going to, go home and tell your law partner about what happened, what would you tell him?
Yeah, I mean, I would tell him you got it exactly right. It was a surprise to all of us what happened this morning. We certainly weren't expecting that. We had, through Brian Steele, we'd lodged objections to having this in camera and out of the public's eye. And we had, also said it was a critical stage of the proceedings and our client should be there. He denied both of those, as he's apt to do with many of our requests. So I was glad to see that it was an open court. But of course, we weren't notified of that until the deputies came upstairs to get us to tell us, well, it's been moved from the 8th floor to our normal courtroom in 1C. So we didn't even know. Actually, the media knew before we did that the media would be there.
The PIO email that was sent out, or you're not on the PIO list, I think.
You're not, and we didn't get. Normally, we would get something from the judge's chamber saying, "Hey, there's been this change," but there we were sitting outside of the 8th floor. That's Judge Glanville's normal courtroom, waiting to follow his instructions, which was to be there outside his normal courtroom at 8 o'clock. And we'd go to the jury room and we'd have this in-camera discussion. And then the deputies got us and brought us down to 1C, which is where we've been having this trial. So it was a surprise. And then, of course, while we were waiting to go into 1C, we were confused. Like, if there's supposedly privileged information here, how are you going to review that in the presence of, outside parties? And then, of course, I don't believe, I'm not going to speak for the other attorneys, but I don't believe there was anything that could possibly be privileged that would have been captured on that transcript. And then when you heard Judge Glanville on the bench today, he pretty much agreed with that because he said he's releasing the transcript unredacted. So hopefully that is the case and we'll see an unredacted transcript.
So you just confirm you still have not seen the transcript yet?
No, I keep checking my email for the transcript as well as the order. And they've had 3 weeks to put this transcript together, so I'm not quite sure what the delay is. But we're waiting on the transcript and we're waiting on the order.
So in terms of good news, are you guys celebrating? Do you consider at least his willingness to send the motion to another judge? Is that good news for you? Is that what you're?
I think it's good news because our request has always been to have a. Sorry, you want to stick your head in and say hello? This is Katie Hingerty. You may recognize her from the case.
Yes. Yeah, thank you. Yeah,
How are you guys doing
today?
So I think we're very pleased because this is what we've been requesting. We requested that we filed the motion for the judge to recuse himself back on the 12th. We believe that he should have granted our request back then under Rule 25 to refer this out to another judge to make that determination on recusal. He failed to follow Rule 25 at that time. He eventually entered an order on Friday the 14th where he more officially denied it and purported to go through the steps that were required, yet still did not send it out to another judge. And that's why we went to, Katie and I filed that motion. We went to the Supreme Court. And then given the guidance we got from the Supreme Court last Thursday, we filed the motion on Friday in Fulton. So, yeah, I mean, essentially we've gotten everything that we requested in our petition for writ of mandamus.
So it basically moots the case, because one thing I was waiting for during the hearing was, is the transcript actually going to be unredacted? Because that was one thing you were asking for, was not just for the transcript to be released, but you wanted to make sure it was going to be unredacted. So
yeah, and
unredacted.
I believe that he said today that we were going to get an unredacted transcript. So I don't believe I need to follow through with that most recent petition in Fulton that we filed.
So does it just go moot like that, or do you need to withdraw it, or is that just
well, in order for it to continue, we have to serve the judge, and that wasn't scheduled to take place today. So if we don't serve the judge, then yeah, that's a civil lawsuit. If we don't serve the defendant, the lawsuit just kind of disappears. Okay. So at the present time, I don't, given what he said today, we'll see what happens, but given what he said today, I don't plan on serving Judge Glanville with that lawsuit.
Okay. Okay. So there are a lot of questions about who is actually going to decide this motion. Is there some chance that all the judges are going to recuse themselves, because basically Judge Glanville is maybe not exactly their boss? People would say the appellate court is their boss, but as the chief judge, they all know him and work with him. Is there some thought that this motion is going to end up in another superior court?
I believe if you look at the case law, that the judges within Fulton County have no choice but to recuse themselves and send this off to another county to be heard. There's good case law from, I have to look up the case name. I don't have it right in front of me, but there's good case law that says that a judge in a judicial circuit cannot hear a case involving another judge that's in that same judicial circuit. There's also an opinion it's opinion 220 from the Judicial Qualification Commission, the JQC of Georgia, that also says that a judge cannot hear a case involving another judge that's in their circuit. So I believe any judge within Fulton will have to recuse themselves, and then this will have to be sent off to a judge elsewhere.
So this could be a lengthy process. I mean, is there any educated guess on how long this could take?
There's uneducated guesses.
Well, let's go for those.
I'll give you an uneducated guess, which would be, this is July 4th week. I can't see much happening here. Well, first of all, nothing happens until the judge gets his order entered. And, I haven't checked my email in the last 5 minutes since we've been talking, but the judge's order has not been entered yet. So once the judge enters that order, the clerk here seems to move pretty quickly. So I imagine she would assign it to another judge within Fulton, off the wheel, or randomly assign it. I would think before the 4th, assuming the order gets entered today, as the judge said he would. But then I think that judge is going to have to recuse themselves. So maybe next week.
So is this going to be a case of like hot potato, where it has to actually be transferred to all 28 judges and they all recuse themselves before?
No. There's no. I think that if a judge in Fulton is following the case law, he or she will have to say that it's going to have to be heard by the reason they can't hear it is it needs to be heard by a judge outside of the Fulton County Superior Court, and that at that point it would go elsewhere. How that process plays out, I'm not exactly sure, because normally it would be Chief Judge Glanville as the administrator of the court that decides where that case should then go. I haven't worked my way through of seeing what happens if Chief Judge Glanville, who I don't believe should be the one making that call, picking his own judge. I don't know what will happen, but I don't think it can be heard by Fulton.
Now, do you know much about the chief judge's duties in Superior Court? I'm more familiar with federal court, and I think they have less control over the judges in federal court, because in federal court, the judges all get their own assignments, but the chief judge in Superior Court has the ability to assign the other judges places, right?
Well, I think I believe in the Superior Court it really is more like federal, where it's more administrative, because cases are assigned out on a randomized basis, he or she doesn't assign the cases out. I think that perhaps on this type of issue, they might normally say, okay, I'm sending it over to this circuit to be heard. But here, yeah, so they don't have, it's more similar to federal, I think.
Yeah. Okay. So is there going to be a motion for bond? I mean, I know we've discussed earlier that Glanville was the one who made that decision, and there really just didn't seem to be a reason to renew it. Are these circumstances, this indefinite hold, is that a reason to renew the bond request?
Whenever I talk to you, I try not to talk about what I'm doing in the future. But
Right.
I mean, I think depending on how this plays out, if the judge is recused, if we have to get a new judge, if there's a period of time where there's waiting, if there is a mistrial, then you might see certainly another motion for bond coming then. These guys have already been sitting in jail for over 2 years. I guess it's 25 months now.
Yeah.
It's actually longer than that. Boy, we're 26 months we're approaching.
Yeah.
So this issue has not been caused by anything that these defendants have done. It's been purely an issue caused by the court system, and they shouldn't continue to have to suffer because of that.
Yeah. Well, and for people who are just joining us, the trial is on hold indefinitely, and it could be, we just don't know how long, because the judge has decided to take the recusal motions that I think he'd already denied every single one of them, right?
Well, the only he denied them all orally from the bench, okay. And then it really needs to be done through an order denying it. And so I filed my motion, and he heard it on the 12th. He denied from the bench on the 12th, but a written order didn't go in until the 14th. There's been no written orders entered in the other 2 motions to recuse.
Okay. And so he made the decision today to send those to another judge. So now the trial is on hold. So Doug Weinstein, who's an attorney for Deamonte Kendrick, that's one of Jeffrey Young Thug Williams' co-defendants, is talking to us about that. He's has one of the recusal motions, and the other is from Brian Steele, and then the attorney for Kayla Bumpus, which that's some other news today, is Judge Glanville walked back that show cause hearing. He's canceled the show cause hearing. And I mean, somebody said that somebody must have gotten it in his ear this morning or over the weekend and told him he was kind of embarrassing himself on a national stage with all this contempt, secrecy stuff, because he really went back on a few things here. But was there a surprise that he canceled the show cause hearing, or what are your thoughts on that, Doug?
Well, I mean, I don't think there was ever a basis to have that. So I'm glad that he did it. I guess I was somewhat surprised by a lot today, not because it wasn't the right thing to do. I just, based on what he said we were going to do today, I certainly wasn't expecting him to do that. I'm glad he did it. And he's from the bench. He said, look, I'm reading some of my notes. Court takes no position on privilege issues or any violations of duty of candor from Kayla Bumpus. The court takes no position on whether Brian Steele's use of proffered information has I didn't even understand what he said. Something about having any impact on the rules of professional conduct or how they might apply to what Brian Steele did. If you remember, the judge was a bit threatening to both Brian. Well, Brian he held in contempt, and then he threatened me on Wednesday when I suggested giving me a certificate of immediate review and said that there was a cloud cast upon the case. He got quite I think it was apparent he got quite upset with me from the bench and told me to tread lightly. Yeah. So we'll see. I'm going to have to drop off now. I'm sorry about that.
Okay, great. Sure. But hey, thank you so much for taking a few minutes to fill us in. It always
great. And thank you for continuing to educate the public about our case.
Absolutely. Your help is always appreciated, and I'll try to keep doing it. Hope you get some time off.
Thank you. Bye.